Welcome to this explainer. Look, if you are a first-year law student in California, you already know the baby bar is that massive, absolute gatekeeper you've got to clear to make it to year 2. So we are jumping right in today. This is your ultimate survival guide, a tactical playbook built specifically to help you completely crush the contracts portion of the exam. Let's get to it. Here is the game plan. We are tackling 5 core areas. 1, UCC versus common law. 2, formation and consideration. 3, defenses and frauds. 4, breach and remedies. And 5, mastering multiple choice questions. Take a deep breath. We've organized this beast of a subject to lower your cognitive load and give you the exact decision trees you need. Section 1, UCC versus common law, the foundational threshold. We have to start here, because if you mess up the governing law on page 1, the rest of your analysis is going to be completely wrong. So you're reading a fact pattern, and you see a mixed contract. It involves both goods and services. Stop right there. The absolute first question that should be flashing in neon lights in your brain is, what is the predominant purpose? Basically, what's the main, essential reason these two parties even made this deal? Are they mostly buying a physical good, or are they mostly hiring someone for a service? And here is how that brilliant little divide works. If the predominant purpose is for a service or for real estate, like hiring a contractor or leasing an apartment, then you apply common law. But if the contract is for tangible, movable goods, like buying a car or farmers selling harvested wheat, boom, you are in UCC Article 2 territory. Nail this and you've unlocked the right rules for the rest of the problem. Moving right along to Section 2, formation and consideration, building the contract. Now that we've got our rules straight, let's look at how an agreement actually comes to life. It all comes down to the holy trinity of contract law. Step 1, offer. Step 2, acceptance. Step 3, consideration. Every legally enforceable contract absolutely needs all 3. You're trekking the logic from objective outward signs of intent. Remember Lucy versus Zemmer, where even a scribble on a restaurant receipt counted because they acted serious, all the way through to the final bargain. Now, step 3, consideration, is where so many students trip up. Here's the secret. Both parties actually have to experience a legal detriment. It has to be a bargained for exchange. Think back to that classic 1L case, Hammer versus Sidway. The uncle promises to pay his nephew money if the kid just stops drinking and smoking. Sure, getting paid to drop your bad habits sounds pretty great, but legally, the nephew gave up his lawful right to do those things. That is a legal detriment, which means valid consideration. Okay, Section 3, defenses and frauds, roadblocks to enforcement. Because sometimes you've got all the formation steps, the agreement is there, but the law still steps in and says, nope, we aren't enforcing this. The biggest roadblock you'll face is the Statute of Frauds. You literally just have to memorize the MyLegs acronym. It tells you exactly which categories of contracts absolutely need reliable written evidence to hold up. M, marriage. Y, contracts taking more than a year. L, land sales. E, executor promises. G, goods over $500. And S, suretyship, meaning you promise to cover someone else's debt. If you see any of these on the exam, immediately start looking for a writing. And you've got to know the difference between these two terms, void versus voidable. They sound alike, but they are totally different. A void contract is just dead on arrival. It's a total nullity from day one, like a contract to commit a crime. But a voidable contract, that one actually survives unless the protected party decides to kill it. So if a minor signs a contract or someone gets tricked by fraud, they hold the power to disaffirm it. But until they do, the contract is alive and well. Section 4, breach and remedies, when things go wrong. Once a contract makes it past the defenses, it dies in one of 2 ways, either perfect performance or a breach that forces us to look for remedies. If things go south, you have to figure out just how bad the failure actually was. If it's a material breach, meaning the whole essential purpose of the contract is completely destroyed, then the innocent party can just walk away. Their performance is completely discharged. But if it's just a minor breach, think of the Jacob and Young's case with the wrong brand of pipe in the wall. That's a minor deviation. The innocent party still has to perform and pay, but they can sue later to recover the difference in value. And when you do sue, remember the ultimate goal of contract law, making the injured party whole. Your main focus is the expectation interest, basically putting them in the exact economic spot they would have been in if everything went perfectly. They get the benefit of the bargain. If you can't do that, you fall back on the reliance interest to pay back their out-of-pocket losses, or the restitution interest, which just stops the breaching party from keeping an unfair windfall. Finally, Section 5, mastering multiple choice questions, the tactical masterclass. Knowing the doctrine is awesome, but applying it under pressure is a whole different sport. Let's look at some strategies from Berkeley Law to actually beat the test. You have to break down the anatomy of what you're looking at. Treat every single question like a tiny issue spotter. Step 1. Read the root. That's your fact pattern. Read it slowly, and whatever you do, do not invent facts. Stick strictly to the page. Step 2. Look at the stem. What exact legal question are they asking you to solve? And step 3. Attack the answer set. Be ruthless. Cross out anything that misstates the law or scrambles the facts. When the exam anxiety inevitably kicks in, I want you to remember this. Nailing multiple choice questions is not some innate talent. It is a skill. And just like any skill, you acquire it through targeted practice. If you are struggling right now, that just means you're in the middle of learning. Adopt that growth mindset. Getting past the baby bar to start your second year is honestly a team sport. No one does it alone. So if this explainer helped clear things up for you, please hit that like button, subscribe to our channel, and seriously, tell all of your study buddies about this. Share it with your group so you can all win together. Contract law is fundamentally just a massive game of rules applied to very specific facts. You've got the playbook now. You know the structure and the strategies. So the only question left is, are you ready to change your narrative, walk into that exam room, and actually win this game? Get back to outlining, and I'll see you in the next explainer.